Okay, today we're going to talk about labor law. There are numbers of labor statutes. We're going to be looking at the National Labor Relations Act of 1935. Now, it has been amended several times, most notably by the Taft-Hartley Act of 1947 and in 1959 by the Landon-Griffin Act. We're going to concentrate, though, on the main provisions and maybe some of what they've been modified to be. So, the one thing is that when it was first written, it provided certain, ULPs, that is, unfair labor practices, that employers could do, and that was under the National Labor Relations Act. What the Taft-Hartley Act is, it applied unfair labor practices to unions and to individuals who maybe did things that were wrong and unfair during a union election. So we'll talk about these things. But let's first talk about what the purposes of the 1935 Act were, because I think it's a very good illustration of something I would like to see in legislation. It used to be that the judges were not content with just looking at the words of the statute, but actually wanted to know what was the intention, what was the spirit of the law. So they would say, oh, it's not the words of the statutes per se as it is the spirit of the law, which actually you could gather from maybe a statement of purposes. So let's take a look at the purpose of this act. And the first purpose, they list 5 purposes. The first purpose they list is industrial peace, because in the early part of the 20th century there had been numerous cases of very violent labor strikes. Strikes where the employer would send in armed police, Pinkertons, or some other group, maybe call up the governor, and the governor maybe would send in the state National Guard and break up the strike. And of course, the unions always claimed that under the First Amendment they would have a right to express themselves and to strike and to refuse to work. And now this is pretty well recognized that even without a union, you do sometimes have a right to refuse to work if there is actually a dangerous condition. But here they were saying, well, we have a right to maybe, as a way of bargaining, walk out collectively as a group in a union. And this was not really regulated and was declared to be illegal. A violation of the market rules, that is, that people got paid whatever they got paid according to the market. And in this case it meant that a lot of people would work on really very terrible conditions and get paid very little in the industrial scene. As a matter of fact, during the Civil War, one of the things that the southern plantation owners would always claim was that your factory workers up north were in much worse shape than our slaves down here. In some cases that may have been true, but either case I don't think justifies the other one. The fact that we're treating slaves bad, that's not good. In fact, that we treat factory workers badly, that's also not good. So anyway, the first one was to promote industrial peace, because the workers would get together and associate together, which they believed they had a right under the First Amendment to do, and maybe picket and maybe walk out, which they also believe they had a right to do, and demand higher wages. Now, an individual walking out can't get necessarily much leverage, but if your entire plant walks out, you've got a problem. Or maybe not even the entire plant, but you need substantial numbers. The more numbers you can get, if a majority of workers leave your plant, you have a problem. And you might try to bring in strike breakers or what the union called scabs. These are, workers who basically are not otherwise employed by the plant. Replacement workers is the neutral term for that. But the unions would always call them scabs because they were coming in and taking their jobs. And in order to defeat them in getting higher wages, getting a fair living wage so that they could send their children to college and afford medical care for themselves and have a pension when they retire and have some sort of life in the industrial age. And so that happened at that time. Anyway, so the first goal was promoting industrial peace. This meant minimizing unproductive strikes and lockouts. so the employer could lock out the workers if they went on strike. 2, promote collective bargaining agreement. Okay, instead of conflict, the idea was that, you know, rather than them having this conflict where the workers are walking out and the employers maybe trying to hire replacement workers and then locking them out, it was thought, well, they should be sitting down and negotiating. So to promote collective bargaining, where the employer bargains with the workers as a group. 3, the third goal, promote free choice of the employees. So it's the free choice of the employees whether they have a union or not. So nobody is forcing you to work at this plant. But if the workers get in there and they organize a union and they get the union recognized by the employer, nowadays of course it's going to be done certified by the National Labor Relations Board, you know, and we'll talk about how that's done. But if the worker, you know, have been recognized, that union's been organized, then you know, one of the things that they're going to bargain for collectively, if they're certified, if the union is certified to represent the workers, they're going to be asking for a union security agreement, which would require every worker to at least pay an agency fee, which is a fee that you pay for the bargaining representation. And the best position for the union as far as they were concerned, and they had this for quite some time, up until just fairly recently, they had the right to have a union security clause that required any worker who had been hired to join a union after he's hired, but not before that, because that was outlawed by the Taft-Hartley Act in 1947. So the 1947 Act said that you could not have a closed shop. A closed shop was one where you weren't able to get a job at a place because it had a union, and you had to be a union member to get a job there. That was outlawed in 1947 by the Taft-Hartley Act. But you could still have a union shop, which is anybody could, without being a member of the union, apply and get a job at the plant. But they would have to, under the union shop agreement, which was part of the collective bargaining agreement, they would have to then join the union. That's largely been changed now. However, in some places, in some states, that may be actually recognized, but in terms of national law, there's been lots of changes. You can still, in most states, get an agency fee arrangement, or at least in 22 states that's true. So there is something that, so an agency fee arrangement, you're not required, if you're a non-union worker, you're not required to join the union, but you actually would be required to pay the equivalent of union dues called an agency fee. Okay, and so people who don't want to join a union object to doing this. The reason for the justification for that originally and still is that this is paying for the representation. And since unions had historically given workers better pay and better benefits and safer working places, there was some justification, it seemed to many people, that there's some justification why they should get these agency fees, even from people who didn't want it. People who didn't want it could go work maybe at a plant that didn't have a union. And there were plants that didn't have unions that, because there were unions and they knew that, and if a plant didn't want to become unionized, one thing would be to provide benefits to the people comparable to what they would get if there was a union. Then they could say to the workers, well, yeah, if you form a union, you won't get any more than what we're already giving you. We're giving you everything anyway. This is what they get. We're paying union scale, and you know, maybe we're giving you something that you can't get at this other place. So I've worked at plants like that, and I've also worked at plants that were unionized. They're just, I mean, there was no real difference in the 60s and the 70s when I worked in these plants. There was no real difference as to how you were being treated. Anyway, so promote free choice of the employees, so they get to vote on whether or not they're having a union. It's not an individual choice, it's a collective choice. If you don't like that, you do still have an individual choice. You can just quit and find a job at a non-union plant. There's plenty of them around nowadays, so it shouldn't be a problem. Right? Or no, it is a problem, I think. And do you really want to work at those plants, or would you rather work at a plant that had a union? Well, you got to look at what pays and how safe and how you feel about all that. Anyway, so Um, so, you know, promoting free choice means that the workers would be free from threats from anyone, the employer or from the union, in making their choice. So the employer can't threaten to close the plant. The union can't threaten to, you know, do something to the union, to the non-union people when they come in. We know what to do with these non-union people when we get in. They can't say things like that. They cannot. So people need to be able to choose freely and not under force of any sort. So the fourth goal was to restrain unfair labor practice, the ULPs that I talked about. Okay, and so there's a list under the Act. You got like Section 7 and Section 8A and Section 8B. Section 8A deals with employer unfair labor practices, and Section 8B deals with union unfair labor practice. Section 7 talks about concerted action and protecting people who are engaged in concerted action, whether they're in a union or not. So certainly engaging in union activities such as striking or you know, picketing, or just simply going to meetings to hear about a union is protected. And you don't have to be a member of the union at that time to be protected for concerted activity. And you don't have to be a union member to have protections under the labor law from, you know, the unions, if that's the case, if they're doing the wrong thing. So anyway, protection of national health and safety is the fifth goal. This comes into play when the president has the power to maybe call off a labor strike if necessary for the national health and safety. This was only done, I believe, a few times. The most famous case was when Truman called off the steelworkers strikes, which was declared unconstitutional by the Supreme Court back in the early 50s when he did that. But yes, and you see that I think Clinton called off an airline strike during his presidency. So curiously, you have Democratic presidents calling off these strikes, which are usually thought, Democrats are usually thought to be the party that's going to support the labor union. So interestingly, that was done. But then again, there was Reagan, and he basically called off a strike by air traffic controllers, but those were federal employees and they were covered by the National Labor Relations Act, which we're talking about. So they were covered by other rules and regulations, and the president had a much freer hand there than, say, Truman or Clinton had. Anyway, protecting free choice. Employees have the right to join unions or not join. You can combine together with co-workers for better working conditions and or higher compensation with or without being a union. You have those rights to do that. Okay? However, of course, without a union, without the power to walk out collectively, you probably don't have much leverage with your employer. The reason for a union, the reason unions have been so effective was that they provided leverage. So I'm sure there were people who threatened to walk out, thought they were invaluable to the employer, and found out the employer didn't think the same way they did. But it's another thing when you have as a collective group of people who are united and walk out. And so and that's how the American people established a middle class, which was the envy of the world. If the employer discharges any person pursuing such a right, that would be an unfair labor practice. So you do have a right to, you know, be in the union and to actually strike or picket. You don't have to go on strike. Sometimes you can picket instead, threaten to go on strikes. You'll see this being done if you've already have a collective bargaining agreement that's going to expire, and you might be, the union might be picketing. They can't strike while there's a collective bargaining agreement, because collective bargaining agreements will contain a clause saying there will be no strike as long as the collective bargaining agreement's in force. But when it expires, that's when there's a danger of employees going out on strike. So before it expires, they'll be trying to negotiate another collective bargaining agreement. If they're not getting what they think they should get, they may ask the workers to vote on going out on strike. So the union has to vote on going out on strike. That's required under the laws that we talked about. So it might be the Landon-Griffin Act, I don't know. But anyway, it was, I think, always something that you needed to do. So it's called concerted activity, going on strike and picketing and talking about doing these things. There are some limitations. You cannot talk about it when people are supposed to be working. You can't interfere with the job. But if you want to talk about it while you're eating lunch with your fellows, you can do so, and the company cannot stop you. However, you cannot do anything that's going to interfere with the work. And so you can't go up to people while they're doing their job and start talking about things that's going to distract them. And it's maybe just the boss that's going to be objecting, but he can object. Okay, so unprotected concerted activity. There are certain things that are attenuated. They're not really closely connected to doing, to the concerted activity that you're doing. So these are unprotected concerted activity. It's not really concerted activity if it's too loosely connected. There are also things that there are illegal means or goals. For example, violence. If you are sabotaging the plant, that's violence, right? If you're sabotaging the plant, or let's say that you're throwing nails under the tires of cars that are entering and leaving the plant, trying to stop people from dealing with your employer, and you're walking the picket line, but you're doing a little something extra there, right? Those are violence, those are sabotage, and these would be illegal means or goals. You say it's concerted activity. You can have concerted activity and picket, but you can't add to it some sort of harm that you're going to be doing. So you got to stay within the law. You can also be prosecuted for doing that kind of thing. So the state or the city might wind up prosecuting you if you're caught doing that. So the NLRB also can impose penalties, but those are just civil penalties. I'm talking about prosecution and maybe some time in jail. Anyway, you wouldn't be the first union person ever put in jail. Anyway, so intentionally disloyal, reckless, or malicious false statements are not protected concerted activity. So you can't be defaming people. You can't go on the internet and defame and say, oh, the boss is, and say something that's not true about him. Say he's a criminal, he's a thug, he's a Nazi. That's maybe defamation. And I don't think Nazi has risen to the level. Although you see it applied to politicians. That's a different story. With politicians, there is oftentimes in the First Amendment recognized a little more freedom for political criticism of people who are running for office, but not for, say, somebody who's a manager in a plant or an owner of a company. You don't have a right to make false statements about these people. So intentionally disloyal, reckless, or malicious false statements. How about public disparagement? We have a good case on that. There was a well-known, I'm not going to give you the actual name, but I'll give you the name of the owner of it. Michelin, Industries is the owner. The Michelin Industry had these sandwich shops that actually the workers were very unhappy because they didn't get sick pay. And so if they were going to be sick, they had to find their replacement, their own replacement. They had to send in a replacement. They had to call in and tell them they were going to be sick, and they had to tell them that they were going to send in somebody to replace them. Well, that's a lot for somebody to do, right? He doesn't know he's going to get sick, and he's suddenly got to find somebody to fill in for him, and beg that person maybe to go in and fill it. Otherwise, he'll be fired. And that's what he's told. So he's told that when he's hired, okay? So according to the company, they think that's fair, but how many places actually did that? And so these workers were very disgruntled about this, and so some of the workers had these posters drawn up, and they would hand them out to people who came into the plant, and it said something about, that they were going to be taking the test to see whether or not their sandwich was made by somebody who was sick or not, And some people thought that might be like implying that you were spitting in the sandwich, but it actually didn't go that far. But it was obviously meant to disparage the company and to affect it. Its marketing would be a very terrible kind of thing to do to a company. And I got to wonder, why would you ever do that? If you're working there and you want to continue working there, you don't want to drive away the customers, then you'll be out of work, And so yes, you're basically putting pressure on the employer, but in a way that could actually not work to your advantage, actually, and it's not really consistent with what you ought to be doing, and it's actually something that's unprotected concerted activity. They can fire you for it, and they will fire you for it, and that's what happened. These people were fired, and they just had no resort to any sort of protection there. They weren't. That wasn't protected concerted activity because they were disparaging the company with the intention of hurting the company and its business. It's not good. Gratuitous, disruptive, profane, or vulgar conduct. So, actually if you make all kinds of a scene at the place where you work to, let the customers know that you're dissatisfied, it may backfire on you. You could be fired for causing that scene, for being a drama queen, so to speak, right? So anyway, you don't want to do that either. So these are not protected. You're protected in your labor activities. You're protected by going to work and going on strike, picketing, discussing the union with people, fine, but not in ways that are harmful. Okay, so Mifflin Enterprise case, Mifflin Enterprise employees protesting a lack of sick pay distributed posters warning customers that they were about to take the sandwich test and find out whether a healthy or a sick employee had prepared their meal. The Eighth Circuit said the posters were misleading. This case actually arose in Michigan. Were misleading, disparaging, and likely to have, or was it Wisconsin? Well, anyway, one of those. And likely to have a devastating effect on the business. Mifflin Enterprises Incorporated versus NLRB 2017. So that was not that long ago. And of course these employees didn't have a leg to stand on. They were not engaging in protected activity. Strikers and reinstatement. In this regard, there are three classifications for strikes. You can participate in a strike. However, there are sometimes some consequences. So if you participate in an illegal strike, you shouldn't be participating in an illegal strike, but if you do go out, walk out, and you haven't followed the procedures for calling a strike, that would be normally that there's a vote. The only way you could ever walk out without having a vote of the membership and following the union method of calling a strike, which you're required to do under the law, would be the only way you could dispense with that is if there's some dangerous conditions that's threatening people's life or health in the workplace. So if there's like some dangerous gas leak, yes, everybody could walk out. You should walk out if there's a dangerous gas leak and you might be poisoned if you stay there. Or if you're in a factory where it suddenly has become dangerously cold due to a blizzard, you could walk out. Of course, I guess you better have a warm coat in the car to get into. But anyway, illegal strikes. Strikers can be fired if they participate in an illegal strike. So before you go on strike, there has to be a vote of the membership. So the union leaders have to call a meeting. They have to give people enough time to get there so everybody can vote. So you can't just do it usually at a moment's notice. You can go out on strike to protest a discriminatory act towards a fellow union member. You can go out on strike for that, but you're going to maybe have to have the meeting called in the proper fashion, which is going to delay you. You can't just immediately do that. So there might be an employee who's been fired, and he tells you he's been fired because he was on the way out. He's telling people he was fired because he was a strong union supporter. Well, he was such a strong union supporter that he was destroying company property, sabotaging the workplace. And it had been going on for a while. Somebody caught him, and that was why he's being fired. And the police came in and took him away. If that's the case, he was engaged in unprotected concerted activity, if you want to call it concerted activity. Okay. And anyway, so he violated the law, and he can be arrested, and he can be fired. If you go out on strike immediately, you yourself are participating in an illegal strike. The union steward or the union leadership can go in and talk to the boss and complain that they think he's being discriminated against, but the boss can stand his ground and say, well, our man says seen him actually destroying property, and we've got the property, and it's all going to be handled by the courts now. So, and we're just protecting our property, which they have a right to do. Anyway, illegal strikes. If you participate in an illegal strike, you can be fired. Normally, the company will come out and tell strikers that they can be fired if they don't return to work. But oftentimes in these situations, they don't return to work, and they will be then fired. Now, then the second kind of strike we'll talk about is the economic strike. Most strikes are economic. I mean, there's almost always some concern for better benefits or more safety or higher pay. Strikers have a right to any current or future unfilled position when they go on strike, when they go off of the strike, when they come back. They would have a right to go into any unfilled position. Replacement workers, however, can be retained. So basically, if you go on strike, the employer can go out and hire scabs, replacement workers. That's the neutral term, right? So you can call them scabs all you want, but in this day and age, there are people who will come in and take those jobs, people who are hungry and desperate. And also, generally speaking, we don't have the kind of violence. Workers today are not shooting at these replacement workers like they may have in some times past. They're not engaging in violence, so you'll find that there are a lot of replacement workers who are willing to come in and take those jobs. And also, there's less sympathy for these union workers than there was in the past, because union workers had been paid quite well, and that's never quite been the same. I don't know if that's still true. I think their wages have been frozen for years, and so I don't know if they're really being paid all that much now. But at one time, back in the 60s and 70s and 80s, union jobs paid fairly well, and there was less sympathy for people like air traffic controllers who went out on strike, and you see them on TV, and they're sitting with their wives, and their wives were wearing these really nice dresses and they looked so well-to-do. And they were being paid quite a bit, actually, and so people did not necessarily, the unions didn't have quite the appeal to the public that they had. And so now we find that people are not joining unions like they used to. But maybe that'll come back. We'll see. Economic strikes. Strikers have a right to any current or future unfilled position, but they don't have a right to take back their old job. And so if there are open positions, the most senior people will take those open positions, even though it's not as good as the position they had before. So they may have had a job where they were able to make more money, because there's some jobs where you maybe make extra for pieces you do, or some jobs are just better or preferred jobs, but they don't necessarily have a right to that job. If they go on strike, the employer can hire people to replace them and keep those replacement workers in their place. Unfair labor practice strike. If you are protesting an unfair labor practice, and that'll be litigated, that'll be maybe taken to the NLRB, an administrative law judge. If he finds that there was an unfair labor practice, then the strikers have a right to full reinstatement when the strike ends. So oftentimes you will see that there's a claim of an unfair labor practice. Typically it's not really known because there hasn't been a ruling on it yet. And so I sympathize with workers who have to decide what kind of a strike this is. But they get to vote on it, and so I can understand if they vote for going on strike, they should have very serious reasons. And I can also understand if they vote against it. Now we'll talk about collective bargaining, which is one of the goals of the union if certified. Now what's that mean? Well, the union is certified after there has been a vote of the workers, not the managers, not your group leaders. They have to be workers who are not company men, basically. And so the workers get to vote on whether or not to have a union. And that happens usually after the workers, some workers have contacted maybe a union, and the union will send out representatives that will talk with the workers, usually meeting them in local churches, local bars, meeting them somewhere where the workers will come and talk. And when the union has talked to enough people, he thinks he can get a big crowd together, he will ask them all to come, and he will then ask them to sign these certificates, these tickets, these cards that say that they want to be represented by a union, or that no, it doesn't say that. It actually says they want to vote on whether or not you know, there will be a union representing them. And so people who are not necessarily wanting a union will be nonetheless urged to do it. So if he can get 30% of the people, of the workers in that plant to sign the cards, then he can go to the NLRB, and the workers will be given an election. You know, so the NLRB will send out workers who will set up booths and hold an election with, you know, little paper ballots that you put in a box, and it's counted, and nobody, and you vote behind a curtain, just like any other election, and then they vote on whether or not they want to. And if the union gets a majority of the people who vote, it will then have a right to be certified. And certification means that it then has a right to negotiate with the employer, who has to meet with them in good faith and bargain. So he has to meet at regular hours during usual times and at usual kind of places for such negotiations. So union official has the exclusive right to negotiate terms and conditions. What does exclusive right mean? Well, basically, once they're certified, then nobody else can actually negotiate for anything with the employer. The worker himself cannot now go in after that and negotiate with the employer for some better conditions, or, you know, something himself. He wants to do it a little more time, got something going on. He can't do that. He has to work through the union typically. And so they have the exclusive right to negotiate things. And, you know, also you cannot form another group who will basically negotiate for you. You have to work through the union. Both sides must meet and negotiate in good faith. We'll talk about good faith in a minute. The union may strike to compel concessions. Okay, if they don't get anywhere in negotiations, the way to get out of that gridlock is to actually go on strike maybe sometimes. Or they can picket. You know, they can put pressure on the employer by those two ways, those two tactics. Picketing and also, you know, appealing to the public, and also by going on strike. Good faith does not require either side to compromise, though. So, you know, each side has to negotiate in good faith, but that doesn't mean that either side has to compromise on their position. So good faith, you're required to meet and consider the other side's demands on compulsory issues. Generally, compulsory issues are those affecting wages, hours, or conditions of employment. So we'll have a list of those in these slides for you. So here's the examples. Wages and hours. Not only the pay scale, but also piece rates. You know, so sometimes people in factories would get paid by how many pieces they produced, and they'd get much more money that way than some sort of hourly wage if they were quick. Shift differentials, so, you know, those would all have to be negotiated. Incentive plans all have to be negotiated. Severance pay should the plant be closed. Pensions, health care plans, vacations and holiday pay, overtime pay rates, profit sharing and stock purchase plans. So any sort of compensation, any sort of benefit that they're going to get after the certification has to be negotiated by the union. And since unions, the only way unions can survive is to actually get more for the workers than what they could get for themselves, and that's how they did survive. Conditions. There are, they can also, you know, negotiate for better conditions. So one of the things that you will usually have in the collective bargaining agreement is grievance procedures, and we'll see a number of things that you get in that thing. So grievance procedures is if you've been demoted, you've been denied overtime, or you feel some complaint, you know, you're not being treated right, you've been penalized, you've been docked, your pay's been docked, you've been threatened with being fired, and maybe they're firing you. You know, you can file for a grievance, and the union will send somebody there to help you with your grievance procedure. You may just be another union member, the steward, or somebody else. Or it could even be a lawyer in some cases. Reinstatement. Safety rules, temperature control, that can be negotiated. So you want to have air conditioning, that could be a demand that the union makes. Whether they'll get that or not depends upon how much power the union has, which depends largely upon how many members that it has and how loyal these members are. Cafeterias. Cafeterias, I used to work in a non-union plant that had a cafeteria, and one of the things they tell you, well, if we had a union, they wouldn't have a cafeteria. That would go away. The cafeteria was very nice. I remember I was a young man, and I came in one day, and I think we were working on a Saturday, and basically the superintendent came over and he said to me, "You look a little tired." And he says, "You been up late last night?" And I said, "Yes, I was." And he says, "Well, why don't you go down and get something out of the cafeteria? Did you eat?" He first asked me, "Did I eat?" And I told him no. He said, "Go down and get yourself something to eat and then come back here." I said, "That's okay?" He said, "Yeah, that's okay." This was what I meant about a company like that. In order to keep out a union, it's going to do things for people that you wouldn't necessarily get in a union plant, because it would be more regimented. It would be everybody gets what the union has gotten for you, okay, and that's it. You know, and that company never was unionized to my knowledge. I also worked for companies that were unionized. I like working in any of those places. They were all, as far as I was concerned, the people who were the union people and the managers in both places treated me well enough. And with the union though, I pretty well knew what the rules were, and so I knew what I was going to get. There was not going to be anything extra. Anyway, but it's okay. Grievance procedures, reinstatement. That would be reinstatement, in terms of if there was some sort of strike, you would be reinstated. So that might be in an agreement. But of course, normally strikes don't occur when there's an agreement in force, so it's usually that not applies. Safety rules, they'll negotiate for safety rules. They'll negotiate for temperature control, cafeterias, effects of plant closing. They can negotiate over effects of plant closing, not the decision to close the plant. That remains a company prerogative. So these are compulsory issues. These are things they must bargain over. Okay. So then there are permissive issues. These are things they can bargain over, but they're not required to bargain over. Compulsory issues they're required to bargain over. Both sides have to negotiate over these wages, hours, and conditions. These, for instance, the company may refuse to bargain over the decision to close the plant. The decision to open a plant somewhere else. So you want the company to agree not to open up plants in Mexico or Taiwan or some other place, and so you want to negotiate over that. They don't have to negotiate over that. They can take it off the table. Hiring and firing of managers, that's up to them. So I've seen plants where a manager would be very popular. Say he's a night manager and he's very popular. During the day they have a different superintendent, and he's not so popular, tough guy, really insists upon people working hard, kind of standing over everybody all the time and pushing people. And he's so the day workers don't like him, but the people at night really like the night manager. So the company decides they don't like the night manager and they fire him. And the workers go in and say, "Hey, why'd you fire him? We really like him." Well, whether you got a union or not, the company doesn't have to take you into its decision of why they're hiring or firing, or change their mind just because you think it would be that way. I've seen it done also with a baseball team, where they fired the manager of the baseball team, and the players said, "Oh, he's a great guy. Why are you firing him?" They replaced him with somebody they weren't so happy with, I guess. And so, but it's up to them to decide who they want to have as management. So that's part of their prerogatives. A modification of retired employees' benefits. So once you retire, there will be certain benefits that are there because of the union contract. And if you want to get something more, there could be a modification, but it would have to be negotiated by the union. Hiring and firing of managers, we already talked about. Subcontracting, which does not affect current employees. So if they're going to build that parking lot, they don't have to use the union workers. Even though they had laid off workers, they don't have to say, "Okay, we're going to hire back our laid off workers and have them build the parking lot." That's not usually what they will do. So that's the company's, these are what we call inter-company prerogatives. The union has some rights to refuse certain bargaining. Union policies are not up for negotiations. So whatever policies they want, what they want a policy for stalling a strike, how many, what kind of majority do they need? Do they need a supermajority or a simple majority? You know, simple majority is all they need to have, but they have to have usually a majority to go on strike. But they could have a supermajority under the contract. They can negotiate that. And they might do that if the company gave them some concession. So don't open that plant in Mexico, and we will, so we can, we won't call strikes unless we get 75% of the workers voting to go on strike. You know, so you could negotiate things that way. So these permissive issues basically allow people to kind of change the whole scenario and do something maybe creative. Procedures and practices relating to election of officers. A lot of things can't be done though because of union scale, and unions tend to all, in a certain industry, follow the same sort of procedures. They don't want to break ranks, so to speak. And so election of officers is something that's up to the union. The quorum requirements, that's up to them. Dues, how much the dues are, that's up to them. How they'll be collected, that's up to them. Voting rules for strikes and the percentage required to strike or end a strike. Union procedures for ratifying the contract. These are all within the union's control. So you have these things that are permissive issues. Then you have issues, so we have compulsory issues, and we have permissive issues, and then you have illegal issues. A closed shop agreement. A closed shop agreement is an agreement that the company will only hire people who are currently in the union that represents the workers at that plant. That's a closed shop agreement. It's illegal under the Taft-Hartley Act, so it's a legal kind of agreement. If you got that in your contract, the court will say we can't interpret it that way. They'll maybe at best interpret it maybe as an agency fee arrangement nowadays. It used to be they would usually do a union, but it kind of depends upon the state you're in, whether or not you can have a union. And so 22 states maybe, but out in maybe 27 other states for sure. Anyway, examples of illegal issues. Hot cargo clause agreements. Hot cargo clause are an agreement that the company will not buy from another company whose workers are on strike. So let's say you work at a bakery, and you bake goods, you bake donuts, you bake cakes, and you sell them to the public. Okay, and you buy flour, and there's a flour company whose workers are on strike. So the union says, hey, we don't want you buying flour from this company because its workers are on strike and they're being nasty to those workers, and we don't want you doing it. They can't say anything about that. I mean, it's an illegal issue. Why is that an illegal issue? Well, there's a policy in the labor law not to allow strikes to spread throughout the economy, because it could get snowball and it could cause problems. So this is a national policy, if you would. Agreements violating employment laws. Say the workers in the plant don't want women coming in there and working side by side. They don't want women doing it because they don't think it's fair or something, And, it was well known that women can do piecework faster than men typically, strangely. And, I mean, this is what many of the engineers would tell me, industrial engineers would tell me that. So maybe they want to discriminate against blacks. Okay. So agreements violating employment laws, you can't have those. Okay. Examples of typical clauses you will find in the collective bargaining agreement. A no strike clause, you will always have that. Because what does the company get in negotiations? Well, it gets a promise that you're not going to go out on strike. That's what, that's the one thing that you've got that they don't have, that they want, is the fact that you could walk out on them as a union. So once they're certified, you can walk out on them, and they don't want that. That's going to be very disruptive to their business. So you can give them that. You can say, we won't strike for this 4-year, 5-year period, however long the collective bargaining agreement lasts. There will then be an arbitration clause. That's if there is a dispute between you and them as to how things are going. Both of you will be required to take it to arbitration. seniority provisions are in there, so it becomes a matter of union rule that the company will recognize seniority. So if there's a layoff, they're going to go by seniority regardless. They can't decide that, well, even though we just recently hired him, we're going to keep him on. They can't do that. They're no longer able to because they agree on the collective bargaining agreement. Union security clauses, so you'll talk about this probably next time. Union security clauses are basically meant to make sure the union doesn't go away, and so we'll talk about them later. Dues checkoff clause. The company will usually be collecting the dues, deducting it from people's payroll check, and so basically they'll typically agree to do that. It's simple for them. Grievance procedures, so that if you do have a complaint, this will be part of the contract. You will have some sort of a substitute for due process. So, government employees would get due process, but you're not a government employee, you don't get that. So private sector workers, that's what we're talking about within NLRA, National Labor Relations Act. It only covers private sector employees. Probationary employees clause. So actually, these are people that are only going to be working a short time. They're oftentimes going to be excluded from joining the union because they'll distort the voting. So let's say there are students that are coming in and working during summer. They're going to vote in the election. What do they want? They want higher pay. They're not concerned about vacation. They'll not be there for vacations. They're not going to, and so they distort what the election. Do they want pensions? No, they want a higher pay. And that's all they're concerned with. So you will have those probationary employee clauses, for those kind of people. Okay. Well, anyway, that's it for today. Like I said, we'll probably be talking next time about union security clauses. There's some interesting things that have been happening with that, so I have some recent cases to talk about, and we'll talk about union security clauses. And that's been changed a lot since the days when I used to work in a factory. Thank you.